No more automatic AOS EAD and H4 EAD extensions where people should have been authorized to work when the extension has been applied. Is it correct, Emily? Is it happening right now?
It is happening starting October 30th tomorrow. We will have a published regulation that eliminates the auto extension of EADs for most categories of EAD. Most importantly, for our audience, that eliminates AOS EADs, so C9 EADs will no longer get the auto extension, as well as the H4 EAD will no longer get that 540-day or 180-day auto extension, starting for cases filed after tomorrow.
So let me understand. If my AOS EAD is expiring, let's say in December 30th of 2025, I file my AOS EAD extension November 1st of 2025. And if the EAD is not approved by the time the EAD expires, I cannot continue working.
Correct, unless you have underlying non-immigrant status with work authorization, like you've maintained your H-1B status or you've maintained your L1 status or something like that. You would not be able to work using that EAD once it's expired, even though you timely filed the renewal.
Wait a minute. Initially, it was 180 days where I could work when the EAD extension has been filed. Then the Biden administration said it's not 180 days, it's 540 days. Now, did the Trump remove the 540 days and put back 180 days, or completely eliminated? That means that once the EAD expires, if my extension is pending, I cannot work.
Completely eliminated. There is no longer any automatic extension for C9 green card EADs or H4 EADs effective tomorrow.
What about the, Stephen, what about the H4 EADs? If I get my I-94 extended, especially, let's say, for example, my H4 is expiring in November, my spouse's H1B is expiring in 2028. I could have gone to India, get my H4 stamped, and come back while the H4 EAD extension is pending. I could have worked for 540 days even though my EAD expires, because my EAD extension has been filed before EAD expires. Now, can I continue working when the EAD expires, or I cannot if I file the EAD extension after November 1st?
No, they got rid of the automatic extension for that. So, I mentioned to Emily, the whole thing is predicated on vetting, but for the H4 EAD, they granted the extension of status already. So what more vetting is there? So I think it shows one of the many flaws of the IFR. But no, long story short, you can't do the automatic H4 EAD extension either.
Now, what about this October 30th deadline, Emily? Is it like anybody who is authorized to work right now? Let's say, for example, I filed my EAD extension before October 30th, but my EAD is expiring, let's say, December 1st, but I filed my AOS EAD extension before October 30th. Is this rule applicable to me?
It is not. So it's based on when your I-765 application was filed, not when your EAD expired. So if your I-765 has already been filed as of today, the old rules still apply. If you qualified for the 540-day automatic extension under the old rule, you will still qualify for it, even if your EAD is not expiring until after the rule takes effect. Only impacts I-765 applications filed on or after October 30th tomorrow.
What about the STEM extension EAD, Stephen? Now, in the STEM extension, Stephen, I can file a STEM extension. While the STEM extension is pending, I could work for 180 days. Is this new rule applicable for the STEM extension?
No, that is a separate regulation that is not being impacted by this interim final rule.
So this is particularly for our clients, this is impacting for the H4 EADs, for the adjustment of status EADs, TPS, even though we don't know it, temporary protection status, those people who file for EADs, that's mostly effective. So this is going to be devastating. We have 300,000 people on H-4 EADs approximately. Every time we file for their extension, we try to get their I-94 extended either by going outside the country and getting the stamping, or sometime traveling to Mexico or Canada and coming back and extending the I-94 based on the spouse's H-1B approval. For them, this is going to be devastating if they file the EAD extension after October 30th. Is that right?
Yeah, I think
And
so.
if the adjustment of status people, now we were happy that we were getting 5-year EAD extensions now, and we're very happy that we were giving 5 years extension. We had this 540-day rule, but if the EAD extension has been timely filed after October 30th, and if the EAD expires, they can stay in the country but cannot work.
Correct.
Stephen, any litigation options for the entire people or individual cases?
Yeah, I mean, I think it's something we are exploring on the IFR. I mean, we just got this about a little over an hour ago. I think the justification for this to be a interim final rule and not go through notice and comment is extremely flawed. It does not, in my opinion, actually present a need for an emergency rule. This whole idea about vetting and all that, where, oh, people could be national security risks. Like, I get that. I'm sympathetic to that. But that's being handled that's not being handled just because somebody gets an EAD approved, right? It's not like they're sitting there. DHS is sitting there waiting on a national security threat that they've identified and is sitting there saying, all right, we can't do anything until the EAD is approved. They can keep working. No, that's not how that's happening. So I think that's a poor justification on it being an emergency rule. And then, kind of generally speaking, this does go into effect tomorrow. And so I do think from my end, we're going to be more aggressive on delay litigation for, H-4 EADs, for the C9 EADs, because, right now they're saying it takes 7 months to adjudicate a C9 EAD, meaning even if you file right on 6 months out, you are likely to lose your job. So I do think we're going to be more aggressive looking at bringing some of those more at the 3-month mark, because, we don't have the automatic extension anymore. So, unfortunately, I do think it's going to get busier on the litigation side.
Emily, any thoughts how this is going to impact?
Yeah, for certain, it is very important for people to file their EAD renewals at the earliest possible date so that you can give yourself as much time as possible to get the renewal approved before your current EAD expires. If you file too close to that end date, you are risking not being able to work. You may need to consider maintaining your non-immigrant status for the last several years with these 5-year EADs, 5-year advanced paroles. It was very possible for people with a pending 485 to be able to forego that non-immigrant status, not renew it because you don't need it anymore. You have work authorization, you have the ability to travel. And you could just rely on your pending 485 to stay in the country lawfully, use your EAD to work, and use your AP to travel. Now, maybe not so much. If there is a gap in your EAD and you have to stop working pursuant to the EAD, but you've maintained your H-1B status, you can keep working based on the H-1B. That EAD lapse does not impact you. Same thing for an L-1 or any non-immigrant status. That's a temporary work visa that authorizes you to work. You may want to consider keeping that valid while your 485 is pending, even though in the past it may not have been necessary. And I also want to mention that there is a comment period for this. So Normally, when a regulation is published, the government publishes the proposed regulation, gives the public 30 days, 45 days, 60 days to submit their comments for or against what should be changed, what they like, what they don't like. And then the government reviews those comments, comes up with what the final regulation should be, and then publishes it, and then it takes effect. This has done everything backwards because they claim they have good cause, which, as Stephen mentioned, they don't really have really good cause. It's very weak argument, vulnerable to challenge in court. But when they have good cause, they can publish this as an interim final rule, meaning it takes effect immediately. We're giving you the final regulation now, but you do have the opportunity to submit comments and they might change it later. So we do have a comment period that goes 30 days to November 29th so that the public can submit comments for or against this rule and potentially get them to change their mind based on that, or maybe narrow it to groups that are more likely to have these security issues and need the vetting. I mean, how many times has an employment-based applicant been vetted? They get vetted when you file the petition. They get vetted when you go for visa stamping. They get vetted when they enter the country. They get vetted when you file the extension. They get vetted when you file the 485. They get vetted when you file the 765. Now you're going to be vetted again when you file the EAD renewal. How many times do we need to vet these people? How many of the employment-based applicants from the time they filed their last EAD till the time they're filing their renewal have committed some new crime that we've not discovered yet that makes them inadmissible? I think the answer is practically zero. So all of this has a huge impact on employment-based applicants for no good reason. They need to, if vetting is a problem, limit it to the types of populations that need to be vetted. Leave the C9 EAD for employment-based applicants in place. Leave the C26 EAD for H-4 auto extensions in place. Do your vetting elsewhere. That's my rant.
Well, and I guess my question too, Emily, is let's be honest. Like, okay, let's assume they want to do vetting. Okay, I mean that could be a legitimate government purpose. How long does vetting actually take? I mean, you know, you can run, our HR person runs background checks in, you know, what, a day, minutes. You know, they've got more sophisticated software through Palantir, through whatever. Why is it taking 7 months to run a background check? I mean, for C9 EAD, we have two questions. Is the 485 pending? And is there some sort of negative thing that would render it deniable, like a criminal arrest or a national security risk? I mean, that should be done in mere minutes. They're intentionally delaying these cases. And now what they're saying is, hey, we're going to intentionally delay it and you can't work. I mean, this is a big, you know, screw you to lawful immigrants who are going through any adjustment of status. That includes family-based too. I mean, a spouse of a U.S. citizen who is pending adjustment of status and waiting for their green card, and it takes forever to get that, now might lose work. So, you know, I don't think their justifications are valid.
Yeah,
There's
and
something.
if we're vetting these people, you know, let's say I give Stephen the auto extension and he has committed a crime in the last 30 days. You do the vetting. When you give the auto extension, you do the vetting, and then you immediately deny his application because he committed a crime. The auto EAD is immediately ended. So why do we need to eliminate the auto extension in order to vet people? Just vet the people and then deny.
Yeah.
And if you
Yeah,
deny, there's no auto extension. It ends.
I think you made this point on social media, Emily. I mean, the auto extension really shouldn't even be necessary, right? If they could kindly adjudicate, which again, for most of the categories that we work with, and remember, we're talking about extensions. We're not talking about initial applications. So, you know, when we talk about an initial application for an H-4 EAD, maybe there's a little bit more that goes into that adjudication. Maybe. I don't think there is really, but or for a C9 EAD. But when we're talking about extensions, you only have to look back to the last extension. You're not going back their entirety of their life. And so how long should this really take? So if we timely did this, the automatic extensions wouldn't be necessary at all. 180 day, 540 day shouldn't be, because most people file early enough that a timely adjudication should result in no lapses of work. And that's why we've litigated before, right? Is based off of that. So we'll see. We'll see how this comes about, but it's ripe with propaganda more than real analysis.
Stephen, I think so that people should plan that they should file way ahead of the time. They should plan to litigate the case though as soon as they file it, or should they wait for 3 months before they come to you?
Yeah.
Because
So
you take 60 plus from some days to
yeah.
get some kind of results. Mostly, it's not guaranteed, definitely.
So
But it takes more than 60 days for you to get this thing rolling. Once you file a court case, they have 60 days to respond. So what time they should come to court litigation, though?
yeah. So one, I mean, obviously, my hope, if they listen to us and they're adjudicating timely, we don't need to talk litigation, right?
Oh,
like you
come
file
on.
at the 6 month mark, you get that
Well, are
adjudication.
you smoking weed, Stephen, lately?
Look, I'm living in a land of fairy tales where USCIS actually does things in a reasonable amount of time, which, by the way, isn't just a Trump administration issue. We did a lot, that's a Biden administration issue too. But the reason I think 90 days is, we have to have some adjudication time. They historically have said we can do these in 90 days, right? This is a 2016, 2017 regulation that said we could do these in 90 days. There's no reason anything. And so my thought with this is, yes, typically the government gets 60 days from the date that they're served to file any lawsuit. So if we do get a little, timely, and we file, we look at cases that are about that 90 days in, that gives them the 60 days plus a little bit of time there if we need to, maybe it's holidays or whatever, just in case. So some wiggle room if you filed, 6 months in advance, especially. So, but again, the litigation strategies are there, I think.
Emily, what other strategic plans people can do to avoid, though? People are asking question. Travel Science is asking, does H1, H4, and EAD premium processing bundle together? Is it still active? This question is coming from Travel Science from YouTube.
Yeah, so although the settlement agreement expired in January, I am still receiving a good percentage of H4 and H4 EAD approvals along with or shortly after the H1B approval when I file all three together and in premium processing. So definitely that is a good strategy and I do recommend it. Otherwise, especially for a C9 EAD, file it exactly at the 6 month mark. You could potentially try an expedite request, which we know those are not usually granted in this administration. So the best thing is to file early and then consider maintaining your non-immigrant status if we're talking about a C9 or GC EAD versus an H4 EAD.
Yeah, it's kind of weird with the H4 EAD, and I think it's intriguing from a litigation perspective because it is all over the place. I do see a good number getting like you said, Emily, either together, maybe within a week, maybe 2 weeks. I'm totally okay. You want to take a little extra 2 weeks, like great. And then I'm looking here. I see some that are 8 months. I see some that are 5 months, and so there's a wide impact on the H4 EAD that doesn't show any rule of reason, which is something we got to talk about in litigation. So yeah, we do recommend apply early. I still think the premium thing is helpful because we do see, at least 30%, probably more, within a short period of time.
Sriram is asking that my AOS EAD combo card is pending. Since it's already pending, Sriram, you don't come under this new regulation. So you are saved in this matter, though. Secretary Neom is commenting, Emily, on this in Washington Times that it is because of Colorado attacks. Do you think so? This EAD, automatic EAD extension people, they have a work authorization to operate guns?
Right? Yeah, just because you've given someone an automatic extension of their EAD does not give them permission to commit crimes. And if they were vetting these people from the beginning and all throughout and not waiting until they file an EAD renewal to all of a sudden now decide we need to vet them, this argument just doesn't stand up at all. I think it goes back to, I don't know how much truth is to it, but I think the Trump administration with Stephen Miller has a variety of changes for immigration planned over time, and they wait until something happens in the media to pounce. And that's exactly why we're seeing this and them trying to relate it to some completely, random issue that happened who happened to be an asylum applicant. How
By
many
the way, it's
EADs are issued to other people besides just asylum? It's not just, it impacts a wider number of people than the number of people that they're actually trying to target. The worst of the worst, all these people they claim they're detaining and arresting and deporting, saying every single person is a criminal and the worst of the worst. In fact, only about 2/3, 1/3 of them have any kind of arrest record at all. 2/3 of the people are not the worst of the worst. That's the same situation here.
Yeah, and it's
And
already
this one third you're speaking have traffic tickets too, Emily.
Right, exactly.
Yeah, and it's already federally illegal for both a statutory and regulatory standpoint for non-immigrants to own guns outside of hunting. I've gone on my Second Amendment rant before on that, but yeah, I don't think EAD changed the statutory law on that.
Well, let me clarify it because Secretary Neumann is a little bit confused on what is authorized by the employment authorization. Let me tell you, Secretary Neumann, shooting people is not authorized even if you give an EAD, period. I don't know where you're getting the impression about that. Any confusion about it should be clarified.
Yeah, pretty anti that.
The STEM extension is this rule is not applicable for STEM extension, guys. This rule is applicable for H-4 EADs, adjustment of status EADs, and if you have filed for the EAD extension before October 30th, this rule is not applicable. Any other?
No, so just file early, make plans, on how on this by filing early. If you have an H-4 spouse, work with your employer on filing early. I mean, that's always the one downside on the H-4 EAD is you're kind of tied to the H-1B spouse. So work on that as best you can, I think.
Anything else, Emily? Stephen?
Nothing from me.
Please subscribe to our channel. You get these important updates, and please subscribe to our blog at rnlawgroup.com. Thank you very much for tuning in. We do bring in immigration updates. Thank you.